number 139, the people of the state of New York versus Brian Hakes. Counsel?
Good morning. May it please the court. Jim Farrell, Sullivan County District Attorney for the people in this case. The people submit...
Mr. Farrell, may I interrupt a moment? Would you like any rebuttal time, sir?
Oh, I would. Yes, please. 3 minutes?
You may, sir.
Thank you, Judge. The people submit that the Appellate Division 3rd Department's holding in this case that no criminal defendant, including those of substantial means, as well as those who specifically consent...
Well, Mr. Farrell, excuse me. Mr. Farrell, are you arguing that there are two different and separate conditions of probation that were imposed on Mr. Hakes? The condition to wear the scram bracelet and the condition to pay for the scram bracelet?
We are, yes.
Okay. And is there a funding stream available?
There is not.
No
And in
funding.
this particular case, the judge determined that the defendant had the ability to pay.
I thought there was a funding stream available, but that the county chose not to seek that funding stream. Is that correct?
No, I don't know that there is a funding stream available that the
Go
county
ahead.
had access
So
to.
explain how there are two conditions.
Well, the condition...
What does the first one fall under? What does the other one fall
Well,
under?
we believe that the first condition falls under 6510 subdivision 4. Now, remember, that subdivision of the law was passed when the legislature took issue with this court's decision in McNair. In McNair, the court ruled that it was illegal for a court to impose an electronic monitoring condition. And
Well, the point was whether or not you could impose something that wasn't rehabilitative when the focus was for public safety. I don't think there's a question about that. So what does the other condition fall under?
The other condition falls under 6510 subdivision 5, which was
Okay.
passed at the exact same time that 4 was passed.
So where under either or both of these provisions is there any kind of statutory text that allows for the imposition of the payment requirement?
Well, if we look to the actual language of 6510 subdivision 5, we find that the court can require the defendant to comply with any reasonable condition that the court determines necessary, and then there's two parts. One, to ameliorate the conduct which gave rise to the offense, or to prevent incarceration of the defendant. And that statute vests broad discretion
Okay, but
in
how
the
does
court.
payment fit under either of these foundational bases for charging the fee?
Because it would be a reasonable condition related to ameliorating the conduct
Well, let's
and
talk
to
about-
prevent him from
slow
being
down, slow down.
incarcerated.
Let's talk about the reasonableness of it. It's $300 a week, $308 a month, is that right?
Well, it depends on, there's a sliding
Well, it's
scale.
$11 a day,
There's-
so it works out to $308 a month. And this defendant was given 6 months jail time and 4.5 years probation, right?
That's correct, that was the initial
So-
sentence.
My math may be wrong, but that's $10,800 in fees.
Well, the judge did not order it to hold the scram bracelet for the entire term of probation.
Okay, but if
His-
it did
his-
go for the entire term, it'd be $10,800.
At the highest level that you cite, but as was indicated in the hearing, the defendant had the opportunity, although he chose to reject the opportunity, to apply for financial assistance. He chose to not
Which
not
would have
fill
brought
the-
it down to $4 a day.
Which would have brought it down to $4 a day, which would have been a half the amount that he was spending on
But he
cigarettes.
says he can't pay anything. Well, put aside the cigarettes for a moment. He says he can't pay anything. Let's get back to the statute, since you say this is the statutory basis for the
Correct.
fee. I'm not really certain I understand the argument about how this ameliorates the conduct. Obviously, the bracelet is closer to this, but how does requiring someone who is indigent paying the fee ameliorate the conduct?
Judge, respectfully, we do not contest the preliminary determination that a failure to pay is willful, must be made before a person may be sanctioned upon a violation of probation.
So are we talking about two different things?
We are.
We're talking about when the condition is initially imposed on the one hand, and the failure to comply with it later on the other hand?
Correct. Again, I'm not suggesting to this court, because Bearden is very, very clear. The Supreme Court case in Bearden is very, very clear. We can't imprison somebody if they fail to pay because they can't.
Well, can we order the bracelet and in the first place, order the bracelet and the payment if the defendant is indigent?
I don't believe that we could order the defendant if he was indigent at the time. But your question raises an important point.
So should there be an indigency hearing before it's imposed, before that penalty is imposed?
Well, I don't think the court needed it in this case, because in this case, the defendant was represented by private counsel. In fact, 2 private counsels
Right.
that he had hired.
I understand that.
He wasn't indigent at the time. He had a
Slow
job.
down. I understand that, but I thought later on that he was represented by legal aid counsel.
He was at the time of the violation of probation, but at the
And that
time of
was-
the imposition,
Let me just follow up then. So then, is that the time when he said he couldn't pay?
that's the time that he said he
So when he was
wouldn't pay.
represented, when he was represented by legal aid, was also the time that he said that he couldn't pay. So people's financial circumstances change. Should they be punished for that?
No, we don't think that they should.
Don't you think this leads to that result?
I do not. I
Tell
think
me
that, I think that you can have a court that makes a determination, and again, that determination was made in this case. In fact, the appellate division didn't even address it. They said it wasn't preserved. Because the judge made a specific finding, I'm not sentencing you because you're indigent.
You know the record, I'm sure, better than we do, but.
I do.
He admits that freely, you know.
You
You gotta give me that.
Answer the
I
first
gotta
part,
give
not
you
the
that.
second.
No question, no question. So when, I'm assuming when he was assigned legal aid, that he went through some kind of indigency review.
Nah, that's not usually done.
Really?
Yeah, really.
You don't fill out a
It
questionnaire?
varies by
You
location,
don't,
doesn't it?
It's not done where I come from.
Yeah.
No?
No, you just say
Well, how
that
do
you
you
can't
make the
afford it.
determination?
You just say you can't afford it and you get free legal aid.
Okay, well, let me, if I may.
It's very rare that someone's required to fill out an affidavit. And in this case, he was offered the opportunity to fill out a financial form. He said no. And Judge, I think that underscores, and I don't know that you can discern it necessarily from the record, I think you can if you look real close, and it was in the PSI, that the defendant's actions are demonstrative of a blatant disregard of authority. And you see that throughout this case.
so-
Didn't want to do it.
Did
So
county
I-
court
I
make a
just-
finding of a willful violation?
He did, and he made a finding that he was not indigent as well. That's very, very
Well,
important.
so that's what I want to be clear about.
Correct.
Let's say we were to agree with you that you can impose such a condition and that you can impose, that you wear the bracelet and that you can impose a condition that you pay for it. That answers, those questions, but in terms of the actual application to this defendant, do we need to remit to the appellate division to determine whether there's factual support in the record for the county court's determination
I don't know that you
regarding
can.
indigency?
I don't know that you can. It's an interesting question, because the appellate
That's why
division...
I'm asking it.
Well, I don't know the answer, I got to be honest, because this court only reviews questions of law.
Right.
Not questions of fact. That factual issue was determined against the defendant by county court. And the appellate division said it wasn't preserved, and they weren't going to look at it. And in fact, they looked at this issue that we're dealing with right now without briefing by the parties. Neither of us had the opportunity. They raised it sua sponte, basically, in their decision, saying, no, you can't impose this condition, even on somebody who can afford to pay. So that begs the next question. If someone can afford to pay, but says, I'm not going to, and now we go down the road, because how about for counseling? How about for mental health counseling? How about for drug and alcohol? No, I'm not going to get Medicaid. I'm not going to go do it, because you know what? I'm going to saddle the taxpayer with that burden. They can pay for it. I'm not going to get it qualified. Where does that lead? Where does that lead us? This is not a situation, I want to make very clear, where the district attorney's office has sought to incarcerate someone who was poor. No, quite the opposite. We sought to incarcerate him when he had means. We asked for 1 to 3 at the original sentencing. And then, when he willfully disregarded his obligation, which 6510 allows the court to impose, he was sentenced by the court. So I don't really know the answer to the question, Judge, because factually, they decided not preserve.
Thank you, Mr.
Thank you.
Farrell. Counsel?
Good morning, Your Honors.
Good
May it
morning.
please the Court. Excuse me, Catherine Friedman, representing Respondent Brian Hakes. Your Honor, in the absence of explicit statutory authority, it is my contention that we have to look at 6510 subsection 5 and the reasonable the reasonableness standard in that section of the statute when looking at this case.
So why isn't the payment incidental to, what is otherwise probably, I think, clearly an okay condition to wear the bracelet?
Well, why isn't the payment incidental to?
Yeah.
So part and parcel of that condition. I think, Your Honors, I don't think that there is any precedent for that particular view that if you're under a term of probation, you necessarily have to pay for it regardless of your means.
But he never made a means application at the time this condition was imposed,
He-
right?
He didn't make a means application, Your Honor, you're right, but throughout.
So really to find for you, we'd have to say you can never do this, because there's nothing in the record here to say they imposed this condition and he couldn't pay.
Oh,
right?
I think there's ample evidence in the record, Your Honor, that he couldn't pay, and he.
Later, there's
he-
evidence that he couldn't pay because he didn't pay, but at the time it was imposed, your client doesn't raise, I'm going to have difficulty paying this, he doesn't ask for a hearing, he accepts that in lieu of a 1 to 3 year prison term.
I think, Your Honor, my client made clear at the probation violation hearing that he felt that he was forced to accept this condition of probation.
But that's at the violation
That's,
hearing.
yeah, and that's retroactive, saying, I shouldn't have done this.
I do think that the testimony at the probation violation hearing made clear that my client, despite the findings of county court, that he was indigent.
Well, what should have happened when the condition was initially imposed? If he said, I'm really not comfortable with this, I don't think I can afford it. What should the court have done at that point?
I think there should have been a hearing. I think that
And what if the court found, you're right, you can't afford it? Then what? Then does he have to be sentenced to incarceration, or does the
No, not at
taxpayer
all.
have
I
to
mean,
pay for
I
it?
think under Bearden v. Georgia, it's pretty clear that the court would have had to take into account other alternatives to incarceration because, in the words of Bearden, it would have been fundamentally unfair.
Okay, but that's not what happened here, because he didn't raise it at the time. He raises it at the violation stage. So is it the same inquiry then? Look at alternatives, other alternatives?
I absolutely think so, Your Honor, yes.
So is that the error here?
I think that's certainly one of the errors, that the court did not delve into that issue or I guess, and again, in the words of Bearden, provide an adequate inquiry.
So, counsel, I just want to be clear on what your argument is. I get this part of the argument. Did you start out with your argument being that you couldn't the judge couldn't impose the fee anyway? Is that where you start, or is your position you can impose the fee on someone who can carry the fee, but not on someone who can't?
That's my argument,
The
Your
second,
Honor.
not the first.
That's correct, Your Honor.
Okay, so I'll ask you the same question I asked your adversary. Where is the statutory authority to impose the cost?
So that I think is the rub in this case.
Okay,
That in the absence of explicit statutory authority, we are left with 6510 subsection 5. That's what we, or I should say you, have to deal with. And I think that the appellate division, although the appellate division didn't explicitly, obviously, state that, the fact that they relied on People v.
But I'm a
Bennett.
little unclear. Is your position that it's reasonable under 5
Yes.
if the person can afford it, but it's unreasonable if they can't? Or is your position it's not reasonable to impose a fee regardless of means?
The first, Your Honor. It's if a defendant can pay, then
they
it's
should be charged.
then it's
Okay, so
then
then how
it's
does it fit
reasonable.
the rest of the conditions in subsection 5?
I'm
To
sorry?
ameliorate the conduct which gave rise to the offense or to prevent incarceration of the defendant? I know your adversary's position is that it fits the former. Is that also your position?
I'm sorry, you'll have to repeat the question.
Okay, I'm sorry, the mic, I'm sorry if you're not hearing me on the mic. I'm asking, since you think Section 5 does authorize the fee for those who have the means to pay, then what section that has these other requirements does the fee satisfy or fall under? Right, it says, as necessary or appropriate to ameliorate the conduct which gave rise to the offense or to prevent the incarceration of the defendant. Which one do you say the fee fits?
Prevent the incarceration of the defendant.
So, I'm not sure I'm understanding that argument, right? You explain that a little bit more to me.
I apologize,
One can
Your Honor.
impose the fee to avoid incarceration of the defendant?
One can
Or a
impose,
court can, I'm sorry.
yeah, a court can impose a fee for an electronic monitoring device to avoid incarceration of a defendant.
Well, the electronic device avoids incarceration.
Oh,
How
I
does
see
the
what you're
fee
saying.
avoid the incarceration?
I see what you're saying.
Because it's a separate condition.
Eh.
Your adversary takes the position that Section 4 covers the device.
Yeah.
But 5 covers the fee. So how does the fee satisfy these requirements of the provision?
That's a great point, Your Honor. That's a great point. I mean, again, in the absence of explicit statutory language, this is what we have to deal with. We have to deal with subsection 5.
So does it then come down to the catch-all provision?
I believe so, Your Honor. Until the legislature passes an explicit statute, I think that
Well-
that this is what we
So would
have.
this also be the same for other types of rehabilitative programs, like substance abuse programs and
Mental health.
mental
I
health? and-
think that there are other provisions in the statute as the New York...
Let me just follow up on Judge Stein's question, because that's a good point. When you're talking about electronic monitoring, Bryce, is that a deterrence device, or is it a device for rehabilitation? The way I understand the cases, costs for rehabilitation are characteristically, say, psychiatric costs, medical costs, characteristically come out of the defendant. Costs for deterrence, put somebody in jail, a deterrent, those costs do not come out of defendants. So where does this fall on the divide?
So it is a cost for rehabilitation, but particularly with
Is it a
regard...
cost for rehabilitation or a cost for deterrence? I guess I don't, it seems to me it's a monitoring device, so it's similar to, so it makes sure that where you are and the police know where you are all the time. It's like being locked up electronically.
I would suggest it is a cost for deterrence because we're dealing with a condition of probation. And
But it's
as...
tied to public safety, is it not?
I'm sorry?
It's tied to public safety.
Yes.
is it
Just
not?
like an ignition, a device you breathe into, what do they call it, the ignition device? Yeah.
Yeah, I did.
Ignition, Judge Wilson's got it right, ignition interlock device.
That's correct, Your Honor, and I think it's Vehicle and Traffic Law 1185, I can't recall the subsection, that specifically allows for the circumstance where an individual cannot pay. And if an individual cannot pay, then arrangements are made with the provider of the electronic device or the interlock ignition device. So I think the rub here is that there is no statutory language.
There's that, and there's a question of, does it matter when the individual says they cannot pay? For instance, I get arrested for drunk driving. I have a job. I'm able to pay for things. Later on, 6 months in, I do my 6 months, and now I'm on probation, and I lose my job as a result of my jail time. My financial circumstances have changed. Is a hearing required at that point, or is a hearing required at the point that the sentence is imposed, and that's the only chance you get at a hearing?
I think you know, in the way you phrase the question, it would
Well, I phrase it that way
depend.
because this defendant seems to fall, at least the sentencing structure seems to fall that way. So-
Yeah, I mean, I think that an indigency hearing could have been
Well,
held.
could the defendant also have asked for a modification of the terms and conditions of his probation?
And
Or
asked for a reduction in, or not having to pay?
Or not
is it
having the monitor.
Not having the monitor?
having some other,
I suppose that probably could have been requested, but again, in the context of this case, that wasn't requested, and...
And I asked,
the-
I may have misunderstood the record. Is there at some point that either probation or someone else had inform the court that they felt that it was no longer necessary for him to wear this device?
Absolutely. He had
Okay, what
abided...
point did that happen, and who was that?
At the probation violation hearing, I believe. It was pretty clear that he was abiding by all the terms of the probation, and he was being successful.
So that was-
Before
I'm
you
sorry.
sit down, I want to ask you the one question that I asked your adversary, which is, if we were to hold that you can impose this condition and you can require him to pay for it, then what? Do we just affirm the conviction? Do we remit it to the appellate division to look at what actually happened and determine whether it was an abuse of discretion? Do we just send it back to the county court? Do we send it to the appellate, it's a legal question of whether it can be imposed is answered not in favor of your client.
Yeah.
Then what?
Well, I would suggest that the court could send it back to either county court or the appellate division to make findings of fact. I would...
So
you would have
think
to
that
bring
the
in...
county court already determined that he wasn't indigent and that this was a willful violation?
I absolutely agree that county court did not conduct a sufficient inquiry that would meet the standards of Bearden v. Jordan. I absolutely think that it failed to meet the Bearden standard. And so county court could conduct or has to conduct a sufficient inquiry and make findings of fact. I think maybe the appellate division, you could send it back to the appellate division and have them determine whether or not, make their own findings of fact. Obviously, you are a court of law, and you can't do that.
And what about your adversary's point that they already said that it was unpreserved?
Well, the court, I would say, with all due respect, erred in that regard, because I think if you look at the record, the Bearden claim was raised consistently at the arraignment, at the parole violation hearing, raised by assigned counsel at the appellate division, and I raised it in my brief as well. The Bearden standard is I think, what really rubs people the wrong way with regard to what county court did. The county court forced someone, if that stands, it forces someone to choose between food and shelter and paying $4,000 a year for an electronic monitoring bracelet.
Thank you, Ms. Friedman. Counsel?
Judge Fahey, to ask...
So, counsel, can I just ask, is it the people's position that the bracelet should be treated in terms of the statutory authorization and this question about paying by means, or if you have the means, like the IID, like the interlock ignition device, that's how it should be treated?
We did suggest that in our brief to the court. We believe, again, we do not believe that if a person is truly indigent, that they should be incarcerated for failure to pay.
Did the IID sections that provide for this safety net, if you will, talk about indigency? What's the standard for
They
that?
do talk about...
But what is the standard?
I believe
it's not indigency.
I don't know that the word indigency is used, but certainly
It's short of
ability to pay.
indigency, right?
Ability to pay, and there's an inquiry made by
The
the
burden on the
court.
individual and the family, does that sound
Correct.
familiar?
Financial affidavit, things of that nature.
So if the legislature has that language, and we can point to it, and it doesn't have that language for the bracelet, why are we able, as a court, to now read the statute as containing language that's not found anywhere in these provisions?
Because I believe that that statute, and when it was passed, remember when it was passed, that statute vests broad authority in the court to fashion reasonable conditions. I don't think it's unreasonable, and I don't think this court can find that it's unreasonable
Right, but how
to
does
have
it-
somebody pay for a device which they can afford to pay for.
You're right,
in
and the
order to-
legislature might very well agree with you, but my question is appropriate to ameliorate the conduct, which is where you say it fits.
Yes, and that-
Tell me how the fee ameliorates the conduct.
And that was back to my point with Judge Fahey, and I want to address what he raised with my adversary. Whether the scram bracelet is rehabilitative or is it a deterrent. I think it's both. Because when you're wearing that scram bracelet, you know that your alcohol is going to be tested every 30 minutes. And that helps you, in part, not consume alcohol, which is good for your rehabilitation. Because when you consume alcohol, obviously, it turns you in a different direction. So I think it's both.
The legislature imposes a bunch of different types of fees, right? There's a crime victims assistance fee, there's a probation fee, there's a DNA registry fee. Those are specified by the legislature. This is not. And my understanding, correct me if I'm wrong, is that if you're a defendant and you are assessed one of those fees and you fail to pay it, your probation is revoked on account of that. Is that right?
Well, it could be if it's a willful violation. That's our position. Our position is if you're given the scram bracelet and then you willfully don't pay for it, reasonably,
And if you
then the
willfully-
judge can incarcerate you.
And if you willfully don't pay the DNA fee, your probation's revoked?
Well, yeah, sure. You could be violated for not paying the court fees as well.
Because-
Again, but there's a means test. Does the person have the means? In this case, he had the means. And I think, back to your point, Judge Feinman, with respect to what can you do, I think the facts have
Well,
been
the question
decided
is,
here.
what's next step is basically.
What I would like you to do, I'd like you to reverse the appellate division's decision that basically says this cannot be imposed in any case. Even my adversary concedes that it can be imposed where someone has the means to pay for it. I don't think that we should have a situation where the taxpayers are saddled with these costs when people who drive their cars drunk crash into brick walls like this gentleman did, and it was his third offense, not his first, not his second,
Yeah.
right? That the taxpayers not be saddled with that, and that people of means be able to meet their obligations. And
So
you know
that
what?
sounds fair.
That's
It's
part
a
of
good,
rehabilitation.
that sounds fair, excuse me, sounds fair, but again, you said the fee comes under provision 5. I'm trying to get you to explain to me how the fee ameliorates the conduct. I understand your argument about the bracelet, makes total sense to me, but you said the bracelet falls under 4. There's no requirement under 4 about ameliorating the conduct. How does the fee ameliorate the conduct?
The fee ameliorates the conduct because ameliorate makes make better. Well, when you meet your financial obligations, you make everything better, including for the taxpayers of the state of New York.
So is your position then that the fee is connected to the bracelet? You can't decouple them, even though you are saying 4 gives you the authority for the bracelet and 5 gives you the authority for the fee, but really they're a package deal. Even though you are decoupling them, you're really arguing that the authority
They were passed together.
is based that way.
And I mean, obviously, we didn't have that statute before we had electronic monitoring come out of
Does
McNair.
it sound
We didn't have
a little,
it.
but does it sound a little unusual to have 4 be the authority for the requirement, the device, and then 5 just be sort of the catch-all, and that's where you would now talk about costs and so forth?
I don't want to be funny, but are you asking me if the legislature is passing unusual laws?
No, I'm
Sometimes
asking-
they do.
No, I know you're not trying to be funny, but I'm asking you about the structure of the statute and a very serious matter about someone being returned to jail because they're not paying this fee, and I'm just trying to get clear the people's position about the authorization for
I
the
think
fee.
the legislature granted the court broad authority to impose reasonable conditions. That's what it says. It's passed in conjunction with, yes, you can order someone to wear a bracelet, a scram bracelet, and now we've got this catch-all basically says anything that's reasonable, and they're passed together. So I think yes.
Yeah, I see
Okay.
your red
Yes,
light's
yes.
on, but
It
I
is
don't
on.
think you quite finished what you were going to say to me. If we get past the first question, that the county court can impose these conditions, what should happen here?
Well, I think that you should reverse the appellate division's decision and find that where a person has the ability to pay, the person can be made to pay. Where they're not, obviously, we don't disagree. We think Bearden controls.
All right,
They
and then
cannot be made to pay.
applying that to this particular set of facts,
Yes,
remit, affirm,
reverse.
reverse.
And because the facts, again, I don't know that the court can get involved in the facts. The facts are determined. The judge said no.
Thank you, Mr.
You willfully
Farrell.
did not pay. Thank you.